So in a previous video, I explained dog bite laws in Oregon in terms of the analysis for economic damages. It's basically a three-layer cake where you have negligence at the bottom layer, which is no longer applies for economic damages, but rather you have this elevated level. It's the middle level the legislature created, basically charging the dog owner with knowledge that the dog might bite. So then you look at knowing the dog might bite, what did you do to prevent it, and was that reasonable? So that's that middle layer of the cake, so to speak. And then the top layer is the strict liability cause of action, meaning the dog had dangerous propensities that were abnormal to its class, and the person was injured because of those dangerous propensities. Then the person who owns the dog is strictly liable. Doesn't matter what they did to try to prevent the bite or the injury from occurring. So that's the economic side. The non-economic side, we have the bottom layer comes into play, that the common law negligence. Did the person know, or should they have known the dog might bite, and did they take proper precaution from preventing the dog from biting? So that's that analysis. And then we have the same strict liability analysis. If the dog was unusually dangerous and that caused the injury, then they're strictly liable. Doesn't matter what they did to prevent. So that's the basic construct in Oregon law, economic versus non-economic damages. What I'd like to talk to in this segment, or speak to in this segment, and it'll be brief, is what time limits does an injured person who's bitten by a dog or injured by a dog have to either settle their claim or to file it with the court to preserve their claim so that a jury could ultimately decide what the claim is worth. So essentially in Oregon, we have a 2-year statute of limitations for these types of actions. It's just a general cause of action for personal injuries, be that medical, financial, and emotional injuries. And you have essentially 2 years from the date of the injury itself to either settle the claim or to file the claim. That's for adults. For children, the rules are a little bit different. For children, they get up to 5 additional years, depending on their age, to file the claim or to settle the claim. So adults get 2 years, children get potentially longer, just depends on their age, and it's conversation is probably more than what this video would really require. But just know that children generally get a longer period of time. Parents who pay the medical expenses for their children's dog bites, they have their own independent claim for reimbursement of those medical expenses. There's a statute that was passed years ago that allows the parent's claim, even though the parent is not a minor, but so long as the claim is simply for the treatment of that child who is a minor, who has the claim for injury involving dog bites, the parent's economic damage claim for their medical expenses, it gets to be told along with the child's claim. So parent, even though they're an adult and they own the claim, they're the ones that pay the medical expenses, they actually have the ability to toll their cause of action for reimbursement of those expenses, piggytailing on the child's claim. So the child's claim is going to drive the timeline for both the adult and the child under that situation. If, God forbid, the dog attack cause the death of somebody, and we've seen that particularly involving infants, where small children are mauled and ultimately pass away because of their injuries, as awful as that is. The estate of the child, including the parents, for the loss of society and companionship of the child, they actually have 3 years, not 2 years, but 3 years to file the claim or to settle it, short of filing the claim with the court. So it's a little bit longer for wrongful death cases. General injury cases, for the most part, 2 years, unless you're a minor, you get a little bit of additional time. If, not that it would happen very often, but if it involved a governmental entity, the rules change a bit. There's a notice period that's very short. You have to give formal notice of the claim itself and the intent to make the claim and what happened and circumstances surrounding it, the date, time, who was involved, so on and so forth. That's statutorily prescribed. That has to go out within 180 days for an adult or 270 days for a child or someone who's otherwise incapacitated. And then after that happens, you have a certain time period to file the claim. It is told, like with the children's general claims, if it's involving a governmental entity, it can be told as long as the parent's claim, so long as the child's claim is told. But generally speaking, if you're an adult, you have, again, 2 years to file your claim. Interestingly, even if it causes the death, because if it's a governmental entity that's responsible for the animal that caused the death of an adult, even though wrongful death generally has 3 year statute of limitations, under the governmental liability statute, that's cut down to 2 years, not 3 years, but 2 years to get your claim filed against the state entity or the local governmental entity. So again, it's pretty complicated. It's fact dependent, depending on age of parties involved, who the defendants are, what causes of action are being alleged or otherwise actionable. But there is time to make these claims. It's just the time tends to shift or to change depending on who's involved and what types of actions are involved. So we're always happy to help people out, look at the cases. Again, it's fact dependent, look at the facts, and do our best to figure out exactly when it is the person has a deadline in which to either give notice or to file their claim or to settle the claim.